In this video, we'll break down the tough two-part legal test Florida courts use to determine what actually counts as a trade secret. We'll get into the specific practical steps that you must take to protect your information, because hope is not a legal strategy. We'll explore the real-world case of a company that almost learned this lesson the hard way, so you can learn it for free. By the end of this video, you'll have a clear playbook how to take concrete action today to make sure your most valuable assets are truly secure. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. Now, one of the most critical yet misunderstood aspects of protecting your business is understanding what legally qualifies as a trade secret under Florida law. Imagine, if you will, for a moment, a Florida company on the brink of total disaster. Their secret clients list, the lifeblood of their business, meticulously built over a decade, was now in the hands of a star employee who quit to start a competing company. They sued, thinking it was an open and shut case of trade secret theft. But when they walked into court, the judge's first questions weren't about what the employee did. The questions were about what the company did, about passwords they never set, policies they never wrote, and simple forms they forgot to have anyone sign. That one simple, devastating oversight, their own failure to protect their secret, nearly cost them everything, and your business might be making the exact same mistake right now without even realizing it. You probably assume your checklist, your marketing strategies, or your secret formulas are automatically protected just because you call them confidential. You think that if an employee walks out the door with your most valuable data, the law will automatically have your back. But in Florida, the law has a much tougher standard than you think. It doesn't just ask if something was stolen. It asks if you did your job to protect it in the first place. So what's the line that separates a good idea from a legally defensible trade secret in Florida? It's a clear two-part test defined by the Florida Uniform Trade Secrets Act, or FUTSA. To have a trade secret, you must prove both parts, not one, both. First, the information must have independent economic value because it's not generally known or easily figured out by others. This is the secret sauce element. The value comes from its secrecy. Think about the formula for Coca-Cola. Its immense value isn't just the taste, it's that nobody else knows exactly how to make it. For your business, there could be a customer list you spent years and thousands of dollars building. It could be a unique manufacturing process or a software algorithm that gives you a competitive edge. The key is that its power comes from the fact that competitors just can't find it with a Google search. But here's the part where most businesses fail. The second part of the test is that the information must be the subject of reasonable efforts to maintain its secrecy. This is the legal system looking you in the eyes and asking, if this information was so valuable, how did you treat it? You can't just call something a secret. You have to actively and consistently treat it like one. Think of it like a treasure chest. It's not enough to say the treasure is valuable. You have to prove you kept it in a locked chest and controlled who had the key. If you leave the treasure sitting out on the table for anyone to see, the law essentially says you didn't treat it like it was valuable. And if you didn't protect it, why should the courts? This is the exact tripwire that so many businesses stumble over. Let's get back to our Florida company. We'll call them Innovate Solutions, a small software consulting company. Their crown jewel was a client and prospect database. But this wasn't just names and numbers. It was a masterpiece of market intelligence with detailed notes on client politics, budget cycles, and key decision makers' preferences. This information gave them an almost unfair advantage. Then their top salesperson, Dave, leaves to start his own firm. Within weeks, Innovate sees Dave pitching their top prospects using eerily specific language that mirrors their own internal strategies. It's obvious he took the list. Innovate hires a lawyer and files a lawsuit under FUTSA. In court, their lawyer perfectly explains the first part of the test. The database's incredible economic value, it's worth millions. The judge nods. So far, so good, right? Then comes the second question. The opposing lawyer stands up and asks the CEO of Innovate, can you show us The disclosure agreement Mr. Dave signed. There's complete silence. The CEO shuffles his papers. Well, our standard employment offer letter mentions confidentially. The lawyer presses, but not a separate detailed NDA? The CEO has to admit no. And this database, the lawyer continues, where was it stored? Well, the CEO explains it was on the company's shared server. What were the access controls in that file, the lawyer asks. Who could open it? The CEO, now visibly uncomfortable, admits, well, all of our employees had access. We trusted our team. So the janitor could have accessed it? The intern on the first day? The questions were brutal. The lawyer then asks about Dave's exit. Did you conduct an interview to remind him of his confidentiality obligations? No. Did you immediately revoke his access to all company systems? There was a delay. Did you ever mark the documents itself as confidential? They had not. As you can see, Innovate's case was just falling apart. While courts look at the totality of circumstances, Innovate's efforts were adding up to almost zero. They had priceless secrets, but treated it like common knowledge. They left the treasure chest wide open. They almost lost everything, not because they couldn't prove the theft, but because they couldn't prove they'd done the bare minimum to prevent it. Now, Innovate's story is a cautionary tale, but their mistakes give us a playbook to make sure this never happens to you. So what does reasonable actually look like in the eyes of a Florida court? It's not about building a digital Fort Knox, but about taking deliberate, documented steps. Here are 5 essential things you need to do. But before we move on, if you're a business owner finding this valuable, do me a favor and hit that subscribe button. We put out videos like this to give you the insider knowledge you need to protect everything that you've worked for. All right, now the first thing you need to do is use contracts and agreements. This is your first line of defense. Every single person who comes near your sensitive information, employees, contractors, vendors, must sign a non-disclosure agreement or NDA. This agreement should clearly define what's confidential and state the obligation continues after they leave. A standalone, robust NDA sends a clear signal both to the employee and the court that you take secrecy seriously. The second thing you should do is control access. It's simple. A secret isn't a secret if everyone can see it. Limit access to only those with a legitimate business reason to know. Use password protection on sensitive files. Implement role-based access controls so a graphic designer can't see your financial projections, and encrypt your data. For physical documents, keep them in a locked file cabinet or restricted access rooms. If you have it, you lock it. The next thing to do is establish clear policies and provide training. Your employees aren't mind readers. You need a written trade secret policy that identifies what you consider a secret and how to handle it. Mark sensitive documents, both digital and physical, with a confidential stamp. More importantly, train your employees on this policy regularly. This creates a culture of security and serves as a powerful evidence that you were proactive. And fourth, you should also manage employee exits. The moment an employee resigns is one of your biggest risk periods. You need a detailed offboarding procedure. This includes an exit interview, reminding them of their confidentiality obligations. Have them sign a document reaffirming they've returned all company property, and critically, immediately revoke their access to everything: email, servers, databases, and key cards. And finally, think physically and visibly. Don't get so lost in the digital world that you forget the physical one. Implement a clean desk policy so sensitive documents aren't left out. Use visitor logs. Put up security cameras. These visible efforts demonstrate to any judge that secrecy was part of your company's everyday DNA. Protecting your trade secrets isn't a one-time chore. It's an ongoing process. You have to be proactive, not reactive. Now, if you're a business owner in Florida watching this and you're starting to see more cracks in your own company's armor, don't panic. It's not too late to fix them. If you're unsure whether your current measures meet these tough legal standards, it's far better to find out now than in a courtroom. In Florida, the law is crystal clear. A trade secret is a secret if you treat it like one. The burden of proof is on you, the owner, to show that you not only had valuable information, but that you actively and reasonably took measures to protect it. You can't expect the law to save you after the fact if you haven't done the work beforehand. While civil lawsuits are brought under FUTSA, other Florida statutes also make trade secret theft a crime, so the stakes are high. So if you remember only one thing from this video, let it be this. The most important question a judge will ask is not what was stolen, but what did you do to protect it? Don't be the company that doesn't have a good answer. Go through your playbook, check your contracts, tighten your access controls, and start treating your secrets like the priceless assets that they are. I'm Santiago Cueto, your Florida business attorney. Be sure to subscribe to my channel and watch more of my videos right here.